Hi, I'm Carmen Sombrowski, and I am going to speak about the legal aspects of getting your affairs in order. For many of the reasons that are being discussed today by the healthcare providers so that people know what you want, one of the most important reasons for getting your affairs in order, in addition to having your wishes fulfilled, is to prevent elder abuse. Elder abuse is prevalent in our society, and so it is very important that you carefully select who you are going to have look after your affairs. Not only your medical affairs, but your legal affairs also tie into this. On the Sunshine Coast, we have something called the Community Response Network. And if anybody suspects elder abuse is occurring to a loved one or even perhaps yourself, the Community Response Network here is able to assist you. In preparing these documents, I'm going to be speaking about these various areas. I won't talk too much about greensleeve, but I will talk about committeeship in the event you do not have your documents in order. In order to prepare documents, you have to have mental capacity. In order to make decisions, you have to have mental capacity. Mental capacity is not something that is black and white. Mental capacity can vary during lifetime. Mental capacity can vary during the day. And so when we are preparing these documents, we have the enduring power of attorney. That is for legal and financial matters. I'm going to get into a little bit more detail on that shortly. There is the representation agreement called the Section 9 agreement. There's a Section 7 agreement, and then there's an advance directive. So mental capacity for these documents varies. And so if we say this is the most capacity that somebody needs, and this is the least capacity that somebody needs, when you are preparing your documents, when you go to a lawyer or when people are reviewing the documents, the highest degree of capacity is required for the Section 9 representation agreement. And the reason you require the most capacity for the Section 9 representation agreement is because it is an agreement where you are authorizing somebody to terminate life support. You're authorizing them to make medical decisions. The next level of capacity, so if this is the representation agreement, the power of attorney is right here. And the power of attorney is the authority to make legal and financial decisions. If we've got the power of attorney here, the next document for capacity is the will. So you can see that you need less mental capacity. And the lowest capacity of the documents we're talking about is the Section 7 representation agreement, which can be as low as down here. So what am I saying? Well, to do a will, you need the capacity, and the lawyers have tests and doctors have tests, and when there's uncertainty, lawyers will sometimes say, hey, doctor, can you write me a letter that this person has a capacity to do this document? I'm not going to go into great detail as to the capacity, but if you think of the capacity to do a power of attorney or a will, the capacity to do a will is you have to know what you own. Basically, you have to know what you own and who your dependents are. So I've got the capacity to do a will. I own a waterfront house. So I've got the capacity to do that. But with the power of attorney, you need more capacity. So not only do you need the capacity to know you own the waterfront house, but you need the capacity to know that that waterfront house that you bought in the 70s for $80,000 is not, oh, it's gone up a bit, it's not worth $100,000, but no, it's worth $2.4 million. And often when I'm seeing clients and I'm asking, what do you own? One of the telltale indications to me that somebody doesn't have capacity is they don't know the value of what they own. So if you no longer know what your house is worth, or approximately what your house is worth, you do not have the capacity to do a power of attorney. you're too late, and so it can have significant consequences. On the flip side, if you are doing a Section 7 representation agreement, a Section 7 representation agreement, you basically have to know people you like or people who you trust. And I've done Section 7 representation agreements for people that they don't know the last name of the person they're appointing, but they know that, hey, this is the person that I want to have look after the stuff that Section 7 representation agreements can look after. So, what are these documents that I've talked about? As I said, the enduring power of attorney is for legal and financial matters. So it is a legal document where you appoint someone, and they're called an attorney. They don't have to be a lawyer. An adult just appoints an attorney who is a person to do certain things. What are those certain things? The power of attorney is probably one of the most powerful documents you can sign in your lifetime. And even though it's not dealing with whether they can terminate life support, powers of attorney are one of the documents that are subject to the greatest abuse when you are doing documents, because you are giving your signature away. So the person to whom you give the power of attorney can sell your home, they can sell your business, they can steal all your money out of your bank account. So when you're thinking, who do I pick as my attorney? It's got to be somebody that you really trust. If you're picking an attorney, you're looking at who you're picking. It doesn't have to be your children. It might be a friend. It might be a professional. This person, if I can sign something to give it away, that person can do it. The only thing on legal and financial matters that the power of attorney cannot do is they cannot do a will, they cannot change beneficiary designations, they cannot sign marriage papers, and they cannot sign divorce papers. So if you think, okay, I'm going to give my son the power of attorney, you start to lose capacity a bit. He can sell your house, he can steal all your money, and if you don't have capacity, what are you going to do about it? Often people say to me, well, the wife and I own everything jointly, we don't need a power of attorney. That's one of the most common questions I have. Maybe 25 years ago, 30 years ago, if you owned everything jointly, you may not have needed a power of attorney. But in this day and age, it is absolutely imperative that you have a power of attorney, because if you do not have a power of attorney, you no longer can file your income taxes. In the old days, often you just filled out the paper forms and you signed them and sent them in. Now most income tax forms are filed electronically. If you do not have a power of attorney, Canada Revenue will not deal with you for the greater part. And as soon as you stop filing the adult's income tax returns, basically you don't get CPP and you don't get OAS because you're not filing your tax returns. Also, in this electronic age, the things like TELUS, Hydro, cell phones, any service, if you do not have a power of attorney, and let's say this contract is in your spouse's name, the other spouse, they won't deal with it. So if you have to change your TELUS phone plan or your internet, Hydro, the first thing they say is, do you have the power of attorney for your husband? And if you don't, you can't deal with it because everything is on the computer and they will just totally ignore you. So it is absolutely imperative from that point of view to have the enduring power of attorney. Now, we get to the representation agreements. Representation agreements, there is a Section 9 and there is a Section 7 representation agreement. Out in the lobby, there's a book called My Voice. You can also access that My Voice online, and there's websites given, but if you just type in My Voice, it'll come up. It's on a provincial government website. So the Section 9 representation agreement, if you recall, that was the document where you needed the most capacity. And The Section 9 representation agreement deals with healthcare, and the components of healthcare are making healthcare decisions, admitting an adult to a care facility, making or helping an adult make decisions with respect to work, social activities, who the adult can associate with, applying for permits, licenses, approval. The representative can make decisions about diet and dress of the adult. The representative can refuse or consent to major or minor health care decisions, even though the adult fails to consent to such decisions. The representative can physically restrain or manage the adult, and the representative can also refuse care to preserve life. That is the Section 9 representation agreement. The Section 7 representation agreement is for the routine care and management of the adult's finances and health care. When I read the My Voice book, or you read all the literature on these Section 7 and Section 9 agreements, I'm a lawyer, I practice in the area, I get confused reading this stuff. So to make it just very, very simple, the Section 9 agreement is for healthcare and day-to-day care. Power of attorney is for legal and financial matters. And basically, the Section 7 agreement is a watered-down version of the two other agreements. It is an agreement where if the adult does not have capacity to do the other documents, you can do the Section 7 agreement. Or if you do not have somebody that you fully trust to make these decisions. So the Section 7 agreement, how it differs from, I'm just watching my time here, how it differs from the Section 9 representation agreement, or the power of attorney. With the power of attorney, you go to the bank, you can take the money out. With the Section 7 agreement, you take the original bill to the bank, and the bank will pay the bill. With the Section 9 agreement, you make the healthcare decisions to the doctor, including terminating life support. With the Section 7 agreement, you can make routine healthcare decisions. You can buy groceries for the adult. You can't sell their land. You can't remortgage. You can do a little bit of stuff, but you are monitored. So in that circumstance, the adult still can be looked after. Now, one of the questions is, who do you pick? How can you, who do I pick to be these? And this is a discussion, takes about 25 to 30 minutes, but we are going to just hop over and go to who you can possibly pick. So for the enduring power of attorney and the representation agreement, you can just pick, A can just pick B, end of story. But if A and B are both in their 90s and B is dead, A is out of luck. You can also pick B or C. Now, picking B or C, that means in law, language is kind of important, and language is what it says it means. So that means B or C. So my father picks my brother or me. So that means either my brother or I can make the decisions. And sometimes for the enduring power of attorney and for the representative, the people do not have to be the same. So if you have, if some people are good with healthcare, some people are good with money. You want to pick people good with money that are honest, decent, don't have gambling, drugs, shopping, those kind of problems. But you know what? They may be tremendous healthcare people, but if they can't control money and can't look after keeping money organized, do not pick them for your power of attorney. So you could pick B or C. Often you might pick B, then C. So you pick your spouse. If your spouse can't do it, then you pick your daughter to do to be the representative. Or what you can say is, I pick B or C, then I pick person D to be the person. So that means D cannot throw their oar in the boat until B or C are both gone. And you can do many, many combinations. Often in the kind of Leave It to Beaver family, you see where husband picks wife, then they pick one of their two kids. So that if I'm in Florida for 4 months, my brother then can look after my parents, because it's either or. We have equal access, we have equal yes power, we have equal veto power. Now, if you pick B and C, what that means is before, where you need one signature, now you need two signatures. So sometimes that is a safeguard. But ideally, when you're picking people that are doing these jobs, you want them to be people that will follow your wishes, not necessarily their wishes, and that they will work together. You do not want to pick two kids just so nobody's feelings are hurt if the two kids aren't speaking to themselves, whether it's for legal matters or whether it is for medical matters. And so I just have a few other options, and because I'm running out of time, we're going to have to move a bit fast. Then we have, you can also pick, like you pick B, then any one of C, D, or E. So there are lots of options as to who you can pick. Now, advance directives, and I'm going to use a few of Carmen Guja's minutes because my time is up. An advance directive, commonly in lingo, people used to call it a living will. A living will has never been a legal document. It is not a legal document. An advance directive is a statement which basically says that you have certain strong feelings about certain treatment, and you want to give your care providers instructions as to what your views are. With the advance directive, it can be used if you have nobody to make your decisions, so that your doctor or care provider can see what your wishes are. But in some circumstances, it is often, even if you have a representation agreement, if you say in an advance directive you want certain things done, then those things must be done, and the representative either does not have to make the decision, but the representative does not have the ability to override the decision. Medical assistance in death, since it's on my slide, I'm going to talk about it for 1 second. Medical assistance in death basically cannot be delegated under a representation agreement. And that is a topic for another matter, but often people ask me, can I put MAID in my healthcare documents? No, you cannot. You cannot delegate MAID. Now, what have we got? Greensleeve, Carmen Guja spoke about it, so we're going to move on from that one. We've talked about temporary substitute decision makers. Carmen has talked about the Healthcare Consent Act. If you do not have your papers in order, basically you've got the Section 16 of the Healthcare Consent Care Facility Act. But what happens is, if you do not have your papers in order, what a committeeship can or may occur. So that word's pronounced committeeship. It's not committeeship. And with it, a committeeship is a court-ordered process where somebody can be the committee of your person or the committee of your estate. So instead of spending $500 to $1,000, maybe $1,500 to get your advanced care plan in order, get the people you want to have look after your stuff, friends, relatives, or the public guardian applies to the court for a court order to say, hey, I want to make the healthcare decisions for this person. I'm the person that's lawfully entitled to. Or, hey, I'm the person that should control this adult that has no papers. I am the person that should control their money. A day in court, you cannot even think of getting a comiteeship order under $5,000 to $10,000. And then the committee, whether it's of the person or of the money, has to report to the court. So by getting your papers in order, you're getting things well looked after how you want them, as opposed to by an expensive and lengthy court process. And basically, all the questions, all the presentation, I'm a lawyer. It's not specific legal advice. Go see your own lawyer. And now I'd like to welcome Chloe Delaney on stage.